Call the next case, please.
Cynthia Allen West versus Roderick J. West.
We'll hear from the appellant when you're ready.
May it please the court, Josh Strickland on behalf of appellant Roderick West. This is a divorce out of the Chancery Court of Sumner County. It was filed in November.
Counsel, you want to reserve any time?
I'm sorry, reserve 5 minutes for rebuttal.
That'll be fine. 5 minutes.
May it please the court, thank you for that heads up. The complaint in this divorce was filed in November of 2022, ultimately resulted in a 2-day trial in April of 2024, and the final decree was entered in June of 2024. For the purposes of this appeal, the essence of the division of the marital estate resulted in $5.5 million for each party and $14,000 monthly alimony in futuro from husband to wife. After the divorce, the estate that was awarded to wife consisted of a $1.6 million home that was paid for, a 2023 BMW and a 2012 Mercedes vehicles, both paid for. The BMW was approximately $90,000, was purchased during the pendency of the divorce. Wife was awarded a home in West Tennessee that the parties had bought to allow her relatives to live there, which generated rental income. Wife was awarded a golf membership at a country club. That's somewhat relevant. I'll circle back to that later. And $3.6 million in cash and investable assets. This was just wife's share of the division of the marital estate. Our position is that with or without employment, wife's needs, as stated and proved at the trial court, are more than met by the division of the marital estate. Wife was 58 at the time of the divorce, husband was 52, the marriage was approximately 20 years. If the trial court had properly accounted for the income, the earning capability of wife and the income from her investable assets, her needs would more than be met. The trial court's alimony award was an abuse of discretion in that it failed to address her earning capabilities, her income from all sources, and it exceeded her monthly need. We don't believe that proper application of the factors, the alimony factors, were followed.
Was there testimony as to how much wife could earn from her assets?
Yes, Your Honor. In fact, there were 4 witnesses that testified in this trial. 2 experts, one for wife, one for husband. They were both stipulated to. They both testified about her earnings ability from her assets. Her own expert testified that she can earn approximately $162,000 a year, which amounts to about $13,500 a month. That alone should come very close to meeting the court's finding that her needs were $14,000 a month. The other expert at trial was that of husband. He was a little more, ironically, conservative in his estimates, but that she would earn over $100,000 a year. And wife verified that, quote, those numbers are correct, and that she anticipated earning income from her investments. Wife's expert testified that she could earn up to, he expected 5% from the investments. Counsel for wife asked, are you good with that 5%? Are you comfortable with using that number? And he testified, I am comfortable with that number. Wife testified she anticipated receiving the income that her expert testified to at trial. The only evidence presented at trial was that she would receive income from her investments. 3 out of the 4 witnesses testified to that, each expert and wife. Husband wasn't really questioned, but we will stipulate that she's going to earn income off those investments. And there was no evidence that she wouldn't. The Chase case was brought up in the appellant's brief. That, I believe, is differentiated because in Chase, the court specifically found one expert testified there would be no income from the assets, and the court found that more credible, more reasonable. Here, the trial court disregarded all 3 of the testimonies of both experts and wife, and we don't believe that it was reasonable to do so. The only evidence presented was that she would encounter income, and according to the factors, factor number 1 in the statute, the court has to consider income from all sources, her earning capability and the income from the assets. Her income, as was presented through her income and expense statement, that was created by her expert. Her expert was allowed to testify as to her expected income after the divorce. His testimony was taken as given and resulted in the trial court's finding, based on the income and expense statement that he created, This is her need. Her need is $14,000. But the trial court disregarded the same expert with regard to her income. His testimony was $13,500 from the assets, and that's nowhere in the ruling. The trial court found that wife would only have income from the resources awarded her in the marital property division. It was proper to find that. He didn't follow up with it. He didn't reduce her need based on her earning capability and the income from the assets, and to do so was an abuse of discretion.
Her earning capacity, it's my understanding she was a registered nurse but hasn't done that for many years and has surrendered her license, and it would take something like 600 hours of medical education to apply for licensure?
There was some dispute over whether it was 60 or 600, but let's say it was 600. I believe the trial court found that it was 600. Yes, she had not worked as a registered nurse in full-time in approximately 17 years. She had worked part-time some. However, I believe it's important to note, she was never a hands-on patient-caring nurse. The trial court found that she could not find work, that her limitations may limit her from being a traditional nurse, doing traditional nurse duties. She didn't do traditional nurse duties. She was administrative. She worked on a phone with a computer. However, there was no evidence that she could not return to work in some other form. And the only evidence was she had osteoporosis and was pre-diabetic and had back pain. That did not prevent her from playing golf 3 times a week. The trial court specifically found because she played golf 3 times a week, he awarded her the golf membership. Her own testimony was, when it came to her contribution to the marriage, I provided daily care to his elderly parents. I went by every day. I shaved them. I took them to medical appointments. My point being, she has earning capability. She may not be able to earn as a traditional nurse. She never was a traditional nurse. But there was no evidence that she could not return to work. There was evidence that she had back pain that did not prevent her from playing pickleball, that did not prevent her from playing golf on a regular basis, that did not prevent her from having a personal trainer. But our position is that she did have an earning capability, not actual earnings, that's not the question. Can she make some money to reduce her need? And not only do we believe she could return to the workforce, we believe that she certainly has income capability definitively from the investable assets.
I mean, the investable assets, those she was awarded in the divorce.
Yes.
What did the trial court do as far as investment income from the awarded assets to your client?
To my client?
Yes.
I may not understand the question.
Well, you're saying that the potential investment income that wife could make off her.
How did it affect the income to my client, or his ability to pay?
No, or maybe yes, but did the court determine your client's earnings include income from those properties, investment income?
I don't think he did when he found his ability to pay. But we're not here to discuss ability to pay. And I'm glad you got,
let me ask you about that. You're saying the wife should have been charged with what she could earn as investments off what she was awarded.
Yes.
But husband, for his income, should not be charged with what income he could earn from his investments.
No, I understand your argument. It was put forth by the appellee. What's good for the goose is good for the gander.
Yes.
My response is need is the #1 factor. Case law is clear. The first question is need. Her need was established at $14,000 a month. Income attributable to the investable assets covers that stated need. I believe it's irrelevant that it increases his ability to pay. We don't get there. Step 1 is need.
I mean,
it's met.
It's usually one of the top 2 factors, isn't it? Need and ability to pay.
But it is the second. And I don't believe if her lifestyle needs to meet that of during the marriage.
Or what's the rest of that?
Or of his after the divorce.
Yes. Why wouldn't his income be relevant to that? His
Because
total
it doesn't
income.
change her need that she established to meet her marital or pre-divorce lifestyle.
Or his lifestyle after divorce.
I believe that that's in the instance that neither can maintain the premarital lifestyle if they were at a 100% and after the divorce, husband's at 30%, wife should be at least at 30%. But there's a public policy issue at play here because there was no fault found in this divorce. And I don't believe the public policy is she maintains a lavish lifestyle, he works to pay for it. I guess my point being, and I believe we addressed this in the brief, I would argue we don't get there because she stated her need, her expert determined her need to maintain that lifestyle, which is $14,000 a month. And even if his ability to pay goes up, her need does not go up, and her ability to pay is met by the investable income that she was not given credit for in the accounting done by the trial court. I'm over. It was going up. I didn't notice. I'm sorry.
Now ran out with perfect timing.
Thank you. I'll
You have your
see you
time
on
for
rebuttal.
rebuttal. We'll hear from the appellee.
If it pleases the court, I'm Helen Rogers, representing Ms. West as I did in the divorce trial. Yes, need and ability to pay shows up in most of the alimony cases. This is a little bit of a different situation because we seldom have a case where husband is earning $1.2 million, $1.3 million, $1.7 million consistently in a long-term job. And that's where we get to 36-6-406, which specifically says, further, where one spouse suffers economic detriment for the benefit of the marriage, the General Assembly finds that the economically disadvantaged spouse's standard of living after this divorce should be reasonable comparable to the standard of living enjoyed during the marriage or post-divorce standard of living expected to be available to the other spouse, considering all of the relevant factors. And there's 12 relevant factors. And here, Judge Oliver made detailed findings as to each factor. He saw Miss West, he saw her testify, and interestingly enough, on the back pain and the osteoarthritis, her husband admitted on cross-examination that he'd seen her having serious back pain. So the judge looked at Mr. West is 7 years younger. He said he was going to retire perhaps at 62. Miss West next month will be 60. And there was 600 hours, and I don't think that was really disputed. There was maybe some confusion, but not dispute, for her to try to reinstate her license. She had not worked as a nurse for over 12 years, and before that, she only worked a little bit part-time. And so she had really let her career go to the side to raise their child and care for his parents. Now, what the court did find, and it was very careful about, was, and I'd ask you to look at a couple of exhibits that I think are very telling. Exhibit 7 is husband's income and expense statement, and he said he needed $23,000 a month to maintain his standard of living, and that was without the house and without the wife's expenses. Her needs were $17,225. If we put those together, the standard of living was $41,000 a month before the divorce, because that's what they said they each were going to need going forward. And so that's exhibits 7 and 8. And then if you look at exhibit 14, what Kurt Myers, our expert, looked at was, okay, if we look at investment income for husband and investment income for wife, and she has to live off of the investment income, what is the effect? And I believe that exhibit and that testimony was very persuasive to Judge Oliver. He mentions it in his decision, but husband would end up at age 65, retirement age, with an additional $14.8 million. Wife would end up with a decrease of $232,000. And that's with, he gives you the assumptions that he made throughout that. But that shows the very situation that we were in. So it isn't just a need situation, it's lifestyle and economic detriment that my client suffered. And then the court, on page 22 of its rulings, page 21 and 22, goes into a really good analysis of what husband has available to meet wife's needs. And he calculates that husband has as much as $25,662 a month available to meet any support obligation. He's got that much excess of his pay periods. Now, you don't normally see that, and there aren't cases, I couldn't find any anyway, that talk about, husband has this much excess and is the ability to accumulate this much additional wealth. And so here you have a husband that has an excess $25,000 a month, and a wife who has dedicated herself to their family. She entertained in his business and helped his career, and the court made specific findings about that. And then we have $25,000 in excess, and the court, I think, makes a very reasonable and sound decision that $14,000 a month should be given to the wife to meet her basic needs. And hopefully she's going to have investment income. One expert calculated it 5%, another one I think was at 5.9%. Hopefully you can earn that. You can't always guarantee you're going to earn what is expected, but that is the way that it was looked at by the court. And I think Judge Oliver's decision is based on the realities of this family. Yes, she got 2 cars. He found that that was the standard. Husband had got 2 cars, and that's what they used as their standard of living. The Chase case is of some help to us. It does say that she can't draw on her retirement income because of her age at that point, but it doesn't discount ever drawing on it. And the Chase case, it specifically talks about the alimony award should be commensurate with the standard of living of during the marriage or the husband's post-divorce, and that's why they gave, in a case where the husband was earning $500,000 and the wife had let, I think, her pharmacy license expire, $7,000 a month in alimony. Here we have more than double that on the husband's side. Mr. Myers also projected in his testimony that husband would earn $1.376, almost $1.4 million in 2024. The award of $14,000 a month is a mere 12% of his income and is not excessive by any means. So, where's the abuse of authority, of discretion, where Judge Oliver finds they had this very extravagant lifestyle before?
And that's not including earnings on his income?
No,
like
sir.
his assets?
That's
That's
earnings
his
from Dollar
income.
General. Yes, sir. Yeah.
If a spouse has income sufficient to meet his or her stated needs, is the spouse going to be entitled to any alimony?
Well, there's a difference in basic needs, your living expenses.
I'm talking about the needs that the spouse presents to the court. Here's my monthly, here's the amount I need monthly. And if the court determines that her or his income meets that amount, is more than that amount, is the spouse going to be entitled to?
Well, first of all, I'll tell you that I had the same inquiry when I read their brief, and the first thing I looked at was the statutory factors. And I know this sounds crazy, but need is not a statutory factor. There are 12 factors, and the word need's not there as a factor. Gonzewski, which is our Supreme Court decision on this issue, on discussing alimony in futuro, said this type of alimony can be awarded where the court finds that there is relative economic disadvantage and that rehabilitation is not feasible. Now, that's the direct quote from Gonzewski. And I think that fits this case perfectly, because what the court found was that there was relative economic disadvantage. She was never going to earn $1 million, even if she tried to go back to nursing. She was going to have a very short career and very limited income. And rehabilitation was not feasible. The Gonzewski doesn't say rehabilitation is impossible. Is it feasible to ask a 60-year-old woman to take 600 hours of training and try and get back in a field where medications has changed, and she testified all this in the record, medications had changed, she didn't have the computer skills. As you know, when we go to the doctor's office down, 90% of it's on the computer. And that's not what she was doing charts in her day. So this is, I think if you look at the Gonzewski definition and the actual set of factors and how they work, you will see that this is a case where there was economic disadvantage. And actually, husband is going to earn more off of his $5.5 million because she took the house. And so he actually has more investable income. And he received a house also. It was the house his parents had lived in the divorce.
Weren't there 3 houses or 3 real
There were.
properties?
Yes, sir. There was the main marital home, and then there was a home nearby that had been purchased for Mr. West's parents. And his father had passed, and his mother had to go in a nursing home. And then there was the home in Memphis that my client received in the divorce, where her mother and I think aunt reside. And were paying her a small amount of rent, and the court did deduct that $900 of rent. We do admit that the court made a math error of $272 on the HELOC. They did order Mr. West to pay the HELOC, and he did include that in his calculation of our expenses. We argued in our brief that that was de minimis. There was also very clear testimony that this husband was also supporting an adult daughter. She had his credit card, he took her on vacations, and he gave her $3,000 a month. So I think the court also looked at the fact that he's able to support an adult child, but not wanting to support his wife, and that was his wife of over 20 years. And that was the status of what the court looked at the time that we had this case. I think that otherwise, unless you have further questions, I've been able to make the points to you that I wanted to make, and that this was a hard-tried case with expert testimony on all of the major issues. And Judge Oliver wrote a very well-reasoned opinion and I think went through the factors in great detail, and there is not an abuse of discretion. Thank you.
Thank you. Here's the appellant rebuttal.
I will agree it was a hard-fought, a well-tried case, and the experts were vitally important for this court. The trial court apparently did not find their testimony valuable, and we believe when he disregarded the testimony of the experts and the wife as to her ability to earn money off these investments, he abused his discretion because he failed to comply with the mandatory statutes in place. As far as need being a statutory requirement, the case law is clear that need and ability to pay are the 2 primary factors, but clearly need is the primary factor, and the relative earning capacity, obligation, needs, and financial resources of each party, including income from pension, profit sharing, or retirement plans and other sources. These investment funds are other sources. There are 12 enumerated factors that the trial court must apply in alimony determinations. If this were as simple as is being discussed, there would be 1, ability to pay. There are 12 enumerated, and ability to pay is not even the primary consideration. This whole statute could be shrunk down to how much money do you make, and we're going to give a portion of that to your ex-spouse. That's not how this process should go. That's not how the statute is laid out. What is your need? Her established need was $14,000 through her own expert, and it is more than met by the division of marital property, which is another factor that the trial court has to address, is what did she get in the division of marital property? So he failed to take into account income from all sources, he failed to take into account her earning ability, and he failed to take into account what she got in the division of marital estate. Opposing counsel stated that she needed that for her basic needs to be met. That is not accurate. She needed $14,000 to meet her standard of living during the marriage. It was her exhibit, her expert. This is how she maintains the same standard of living, by $14,000. She's getting that need met through the division of marital property and the income that comes along with it, not just her basic needs. She's got a $1.6 million home that's paid for. She's got $80,000 in vehicles that are paid for. She has $3.6 million in cash and investable accounts. She is not going hungry. He is continuing to work. He has the ability to pay. Our question is, does she have the established need that is not being met? And case law says that her need should be established, and then earning ability and income from all other sources should be subtracted out of that. And we believe that failing to do that was an abuse of discretion, and there is nothing to support an alimony award that exceeds her stated needs. No statute, no case law. Both experts testified that with no alimony, she would remain a millionaire and have all of her needs met. Thank you, Your Honor.
Thanks to both counsel. We appreciate your arguments and your briefs on this.